All right, gentlemen.
Good afternoon, Your Honors. My name is Adam Crowder. I'm with the law firm of Rainey Kaiser. I'm the attorney for the appellant. With the court's permission, I'd like to reserve 4 minutes of rebuttal time. 4 minutes of rebuttal time.
Okay. I don't hear as well as I used to.
Your Honors, this matter, like I said, I have the privilege of being able to represent Miss Betty Jane Davis. Miss Davis is an elderly lady who is in her 80s that unfortunately had a situation with her daughter and the daughter's long-term boyfriend, in which the trial court in this matter found that there was a misappropriation of funds and conversion of funds. And so we have this ruling that was made, and unfortunately, the court reduced the overall judgment that was made to Ms. Davis, my client. And the reasoning, the rationale that the court had with this matter is that the court found in its conclusion of law that my client, the plaintiff, and also the defendant, Ms. Davis, had conspired to basically defraud Medicaid. And so based on that, the court found on its own sua sponte that there was unclean hands and also bad faith on behalf of my client. And so he reduced the judgment. We were originally seeking $47,855.72, and the judgment was for a lesser amount. We ended up having to go back and actually get that kind of cleaned up on a math error, but it was the ultimate judgment amount was for $26,041.06 plus court costs. In addition to the conversion and the misappropriation, we asked for also that the court award damages under the Tennessee Elder Abuse Statute, most notably that we were asking for attorney's fees. And the court stated that in this matter, the elder abuse law did not apply. And basically, what the court seemed to be focused on at that point was that there was a domestic altercation, for lack of a better way to put it, that occurred in December of 2022. There's two sides to every story, and in this particular situation, there's the story about whether or not my client was pushed or whether my client tripped. Be that as it may, that's one issue where right after that, the very next day, the defendant pulls out $15,000 of this money that was being held in an account for my client's benefit. The defendant could not tell the court why she took the money out. She could not tell the court what the money was used for, other than, she did not state in her testimony that it was used for the benefit of my client. The defendant, Ms. Davis, the daughter, later admitted also that the rest of the money that was being held in the account is now all gone as well. And so we have the issue of this altercation, and then also apparently the way that the statute reads is that if you have an elderly individual, that there's a theft, and that can be by abuse or by fraud or otherwise, coercion, that those would be the reasons that the elder abuse statute would apply. The court does not find fraud. The court did not find that this domestic abuse or this domestic altercation raised to the level, according to his order, that met the burden to be able to say that there was an elder abuse claim. However, and what we're arguing on this appeal is the fact that since the court did find that there was conversion and misappropriation, that is finding theft. And that's exactly the type of thing that the legislature is trying to provide a protection for, is for this special class of individuals, the elderly in our communities, that are not being taken advantage of, and especially in a situation where it's a family member. So we've got a family member who took advantage of her mother. The record, it states that my client had dementia. She's over the age of 80. She had...
What are you relying upon for evidence of the health issues?
So with our statement of evidence, Your Honor, we provided the testimony as far as the information that we had. We also had Dr. Nass's deposition that was provided to the trial court prior to the trial. as the court well knows, the doctors aren't able to be deposed, or they're deposed and not having to be subpoenaed to trial. We submitted that deposition prior to the actual trying of the case, and so we submitted that also as part of a statement of our evidence.
And you believe that establishes that your client has significant, or well, I'm not sure, what's the standard here as far as health issues?
Yes, Your Honor. So on this, it states that basically with the statute, Your Honor, that there has to be some sort of physical or mental issue with the plaintiff. And in my case, it doesn't say that there has to be a finding of dementia. It doesn't say that there has to be a finding of Alzheimer's. It can be anything just because of old age, that's the basis that if there's something that's going on with an individual, that allows them, because of their age, because there is a mental or physical condition that they have, and then there's the theft. If you have those three elements, then that person has a cause of action to where they can get compensatory damages. They're able to get attorney's fees, and there are also other damages that they could seek as well.
So you think what the doctor said in her deposition qualifies for providing you, well, I guess, the prerequisite to the health issues?
I think, yes, Your Honor. I think the deposition, on top of the fact of the testimony from Ms. Davis, the defendant, and then also my client, it's undisputed that she was suffering from depression, that she also had, she'd been taking depression medication for a long period of time. She had had a very serious urinary tract infection. She had also had high blood pressure. And then my client disputed whether or not, to be completely frank, my client disputed whether or not she had dementia. The daughter stated she had a long history of dementia. She had confusion and agitation, and she had memory loss. And so these were items.
The doctor seemed to think she was doing pretty good.
The doctor seemed to think, with all due respect, Your Honor, the doctor seemed to take the position that it was difficult for her to make an opinion on what her condition exactly was. She was definitely in an altered state because of the fact of either a dementia or because she had not been on her depression, and it had exacerbated so much that she was not in her right mind, and she needed to be on some sort of medication.
Well, didn't they ultimately determine it was the depression medicine?
I think she does end up getting her back on the depression medication, and then there's also memory loss medication that's prescribed as well.
She's still driving?
She is driving now, yes, Your Honor.
Well, I don't know about now, but
well, I mean,
she was driving at the time of the deposition.
There was some of the, yes, there was, she was able to drive at that point in time, but I also think that what we had is a situation to where there are various things wrong, and I don't think that based on the statute, the way that it reads, I don't think it's a high threshold to be able to say that you have to, this is not like a situation where you're having to show that there's, she doesn't know what today is, who necessarily her family members are. The fact that she's got any health conditions really that are going on that could influence her to where she is more susceptible, which I think is what was going on here.
So let me jump around on you here a minute. Your client receives this money.
Yes.
And she deposits it in this account.
Yes, Your Honor.
And she's not on the account.
No, she is not, Your Honor.
And as far as she knows, and as far as the court could, I'm assuming I've got the findings right here, if not, correct me, she believed that the account was Mr. Creasy's account.
Yes, that's correct.
And he was the only person on there.
That's correct. That was my client's testimony at trial, is that out of all the people that she was dealing with, unfortunately, that was the person that she trusted the most.
Right. She didn't trust her daughter, nor did she trust her son, but she trusted Mr. Creasy.
That's exactly correct.
Okay. So, but there were no safeguards put in place about getting the money back or anything?
There was not.
Okay.
There was not. And so the fact is that my client who had
two deposits.
There were 2 deposits, yes, Your Honor, and that was part of the math issue that we had to go back and rectify with the motion to reconsider to be able to correct the judgment. Unfortunately, there was about a little over $9,000 that needed to be added back in, and we got that clarified, and the judge didn't have an issue with that, Your Honor. But there were 2 deposits, and the money is sitting there in the account until, like I said, we have the issue of this episode in December of 2022. The money is then pulled out, or $15,000 is pulled out at that point in time. And then the history again goes to shows that my client was trying to make contact with Mr. Creasy. She sent him a handwritten letter. She sent him by certified mail. She had legal counsel send him letters. She's not sending anything to her daughter. She's only sending things directly to Mr. Creasy because that's who she believed was the only person that was on the account. Miss Davis, the defendant, actually testified too as well about the fact that the account would show on the account statements only Mr. Creasy's name because of the fact that she had had previous bad relationships with some ex-husbands that were trying to stalk her. And so I bring all that up in the fact that that's what my client, testified to. There's no dispute about any of that. She never discussed anything about trying to defraud Medicaid. She didn't remember even having the meeting. But it was clear that, at least from the daughter's standpoint, she knew of this situation that had happened with her boyfriend's family, and that they needed to make sure that she didn't lose her benefits because of this inheritance that she was going to get. And so based on that, after they had the meeting with the Division of Medicaid in Mississippi, that was when it was decided to go ahead and put the money into the account there in Henderson County. Thank you.
Thank you. You've got your rebuttal time.
Good afternoon.
Good afternoon.
May it please the court, I'm Sam Henson. I represent the appellee. Your Honors, just to start this off, my client, well, I've got 2 clients, but my client, Defendant Davis, has maintained from the beginning that the money that was deposited into this account was a full gift from her mother, one that they had discussed prior to the money being deposited. The appellant has argued that just 2 essential things in their brief. The appellant has argued, number 1, that the court erred in raising sua sponte the affirmative defenses of bad faith and unclean hands. And to an extent, I think the appellant's right on that. I don't think the court...
That's my question to you, Mr. Henson, is do you agree that those are affirmative defenses?
They are affirmative defenses, and I think the appellant is right that the court probably erred in raising those sua sponte.
I was going to be interested in how you explained if they weren't raised, how the court could raise them for you.
Yes, sir. I think they are right on that. Although my argument is, even if this court, if we strike that language from the order, it doesn't change the ruling from the court. And that's supported in 3 separate places on the order, the November order from the circuit court. First off, essentially what the court found was that the appellants hadn't carried their burden of proof in this case. The court said that in paragraph 2 of the order that the plaintiffs did not intend to make a complete gift to my clients. In other words, the court found that the plaintiff did intend to make at least a partial gift of that inheritance, although we maintain the court did err in that it should have been a completed gift.
Explain to me what you're relying on, what actions, what statements, what the evidence will show that your client is relying on to make that gift.
Well, she testified at the trial that her mother gifted this money to her.
She, your client?
My client, the defendant Davis.
Well,
yes, sir.
Normally, the person receiving the gift testifies it was a gift.
Yes, sir, that's true, and she did. She testified that it's a gift, and that was the argument I've raised in my brief, is that...
But what actions did the mother, I don't want to confuse there, but her mother take that you're relying on to substantiate a gift?
Yes, sir. Well, first, the mother had her own bank account in Mississippi that she had been depositing money in. So she takes this separate money and specifically deposits it in an account owned by Mr. Creasy and Defendant Davis. And the court did find, based on the testimony, that when she deposited that money into the account, that she deposited it into both defendants' account. The court uses...
Did the court find, and I hate to interrupt you, but want to kind of have a dialogue here
Yes,
for a moment. Did the court find why she deposited that money in the account?
I think the court felt, based on the proof, that this was in an effort to...
It did not articulate a reason?
Well, I think the court felt it was an effort to defraud TennCare.
Which, what's that got to do with anything as far as this is concerned?
Again, our position has always been that she deposited the money into that account as a gift to my client, which is the sole reason she came from Mississippi to Henderson County to do that. And further proof of that, Judge, is that the plaintiff Davis, the mother, testified in the hearing that she did this out of her own free will, that she was not talked into it, she wasn't coerced, she wasn't forced or threatened in any way, that she chose to put the money in an account, in my client's account. And I think when you take that, plus the fact that for over a year, she never made any request to have any of the funds returned to her. She only made the request to have any funds returned to her after she moved in with her son, my client, Defendant Davis's brother, and it was clear at trial that those two folks just don't get along at all. They don't like each other, and they hadn't liked each other in a long time. And my client maintained that she believed it was the brother that was upset because at the same time Plaintiff Davis deposited the money into my client's account, she also gave her son $10,000 out of that money. And so you've got a gift to the son, and then you've got a gift to the daughter, which is why we believe it was a gift. Regarding the elder abuse, Your Honors, the TCA 716120, which was cited in both of our briefs, I think, states that in order for elder abuse to occur, there has to be a theft of such person's money or property by fraud, deceit, coercion, or otherwise. So it's not just that there was a conversion or a theft, and I would maintain those are two separate actions there, but it has to be by fraud, deceit, coercion, or otherwise. And the court found, based on Plaintiff Davis's own testimony, that there was no fraud, coercion, or force or threats of any kind that resulted in this money being deposited. She did this voluntarily and out of her own free will. And again, this was based on the testimony from both my client, Ms. Davis, and the plaintiff client, Ms. Davis. And I think what happened is that the court just simply found my client, Defendant Davis, more credible than Plaintiff Davis. And then...
Let me pose a question to you.
Yes, sir.
I'm still thinking gift here.
Yes, sir.
As I understand it, the reconciliation of the account shows that certain funds were deducted from that account to pay for upgrades to the Mississippi home.
I believe so.
That was presumably to benefit the mother here.
Yes, sir.
So is that consistent with a gift?
Well, I mean, up until this happened, my client and the mother, they had a great relationship. I mean, they were with each other all the time. And
You mean the altercation?
before the altercation, yes, sir,
Right.
before the December
That's
20. That's when things went sour.
The precipitating event,
Yes, sir.
I assume.
That's when things went sour. But prior to that, my client she was the one that took Miss Davis to her doctor's appointments, to her TennCare appointments, whatever those may be. She basically lived down in Mississippi with her mother. And there had been talks about selling that house in Mississippi, and I think some of that money was used to try to get that ready to be sold. Although, as far as I know, it never was put on the market or anything of that nature. But I think that's all that was just a daughter helping a mother out.
So that would be, following your theory,
Yes, sir.
and correct me if I'm wrong, it was a gift to the daughter, and the daughter gifted back those proceeds to the mother for the upgrade of her house.
I think that would be an accurate way to state that.
Okay.
And again, I do rely heavily on the fact that when, around the time this money was deposited, mother plaintiff gave both her children a sum of money. She didn't just give my client money, she gave her son money too. And I think that's what a lot of this boils down to, is the son was not happy that the daughter got more money than he did out of the inheritance. And again, this isn't necessarily for today, but we had certainly argued that it was the son attempting to influence the mother to try to get the money back, which is why she didn't request any return of the funds till almost over a year later. And yes, sir.
I'm hung up on the gift again. Let me go back and ask you one more question about that. How can you consider this to be a gift if it's undisputed, I assume it's undisputed at this juncture, that mother was unaware that daughter was also on the account? Is that?
That is disputed.
That is disputed?
Yes, sir.
Okay.
And I pointed that out in my brief, that my client testified and during the hearing that the mother always knew her and Mr. Creasy were on the account. And again, it just appears that the trial court found my client's testimony to be more credible in that regard than the mother's.
Okay.
In fact, I believe my client testified that from before they even came to Tennessee, that she was aware that Mr. Creasy and my client, both their names were on the account.
Okay. So the trial court determined that, as far as a factual finding, that the mother was aware that the daughter and Mr. Creasy were both on the account.
I believe so, and I'm basing that on the specific language in the order where the trial court used the term defendant's account as a plural and not singular.
Did it make a specific finding in either the order or the statement of evidence?
Yes, sir, I believe. I can.
I'm sorry, I'm taking up your time for that.
I'm not certain which specific paragraph it was, but the court found that plaintiff deposited money into, again, defendant's bank account, and that was plural. That was used as the plural version of that. And again, I think that was based on the testimony of my client, Ms. Davis, when she testified that the mother always knew that both names were on that account.
Okay, I'll find it. Go ahead.
And then just to address the issue of the elder abuse, one other point is regarding that December 2022 incident, again, my client testified at trial that the mother injured herself when she tripped. It was either over a dog or while they were trying to get a dog back in the house, the mother tripped and fell and hit her head. My client's the one who called 911. She went to the hospital with her mother, and that's when things went sour. But there were no police or no charges filed in that matter. And again, I think that was more of an accident than it was anything. So I don't believe the court erred in finding that this matter did not rise to the level of elder abuse. But I do think to some extent the court erred in not finding a complete gift based on the actions of the mother. And I'm happy to answer any questions.
Thank you.
Thank you.
I want to address a couple of issues, Your Honors. One of the first questions that was asked was about the affirmative defenses not being raised, and I believe opposing counsel said that didn't change the ruling. It completely changed the ruling. The judge's own findings say that, because what he says in number 5 of his order on November the 13th, 2024, the plaintiff made the initial deposit in the defendant's credit union account that is the subject of this litigation in bad faith with the intent to defraud. She is barred from full recovery based on the doctrine of unclean hands. That's the only reason that is given as far as why the recovery was not the full amount. Not because there was a finding there was a gift. In fact, the court specifically said there was not a gift. And so I just want to be clear that's what we've got here, is because the court took that extra step on its own sua sponte, that's how we got to the point where we don't have the full judgment amount. The other thing that I would state on this is that number two, it talks about that it was not a complete gift, just to be clear on the conclusions of law and the court's order. And then, like I said, number 5, it's the avoiding of Medicaid is where the court was coming up with this. And again, like the court, Your Honor, Judge Stafford said earlier, that didn't have anything to do with the parties in this lawsuit. That's not, Medicaid is not a party to this. The Division of Medicaid in Mississippi or TennCare, neither one of those are parties to this lawsuit. This is just a family dispute, unfortunately. There's not a ruling by the court as far as who's more credible either. There's no finding of fact that the plaintiff knew that both her daughter and her boyfriend were on the account. Her testimony was that she believed it to just be the boyfriend's. The daughter's testimony was that that she knew, and the boyfriend said, "I don't know anything." So he kind of has his
Just
head.
my account.
It's just my account, and I'm staying out of it. It's basically the approach that he's taking with this, and so again, we come back to the issue of when the court finds that there's misappropriation. That should have been the basis there in and of itself to find the elder abuse. And it's kind of like someone making the statement that someone's kind of pregnant or half pregnant. You either are or you're not. And when you find that there's conversion to misappropriation in this type of situation with an elderly individual, when there are health issues that she has, the court should have found that this is a situation to allow for the attorney's fees. This is exactly the type of person that needs to be made whole. And so we would ask that the court remand so that the full judgment balance would be allotted to my client, and then also that the court remand with the instructions that the elder abuse statute apply. Thank you.
Thank you. Thank you, gentlemen. We certainly appreciate your briefing, your argument, and we will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be excused, and we will be in recess to the call of the docket in the morning.